All right, ladies and gentlemen, good afternoon and welcome to the show. I don't have a name for the show. It's just the show. That's all we call it, the show. Like when you're playing baseball, you make it to the show, you're big times, you're in the big leagues. This is not quite the big leagues, but it's the show. And we will be covering what I believe to be something very important today. I jumped on with John for briefly on the Daily Herald. Badlands Media, thank you for the raid there, and wanted to promote this because we're going to go through the Amicus, Amici, I don't know. It's an inside joke. If you saw this on Daily Herald, me and John had an argument or a debate, a scuffle, a kerfuffle about how to pronounce that word, and we were kind of both right and kind of both wrong. I don't even know necessarily, but hey, so we're going to go through this brief that was filed in Fulton County. It's a friend of the court, amicus brief. You can file this as hey, supplemental information that we think you need to know. And so the story here real quick, there's a hearing going on right now. I think it's going on right now in federal court regarding the Fulton County ballot seizures that the FBI did a couple months ago. And the county is still trying to get the ballots back, and they've made motions. The mediation failed, which is good, right? The mediation failed. That's good. But now they are trying to claw it back based on the warrant itself, saying that it's not a probable cause affidavit. It's based on debunked conspiracy theories and everything else, and saying that the state has violated, or the government has violated the county's Fourth Amendment rights by stealing those, or taking those, seizing those, whatever you want to call it. So we are going to read through this brief here. I do want to, let me see, got to get it pulled up here. Bear with me 2 seconds. I had it pulled up, and then while the intro was playing, I clicked the wrong thing, and I took it down by accident. So there we go. Oh, there we go. All right, so we'll share that screen, hide that, and boom, there we go. All right, so am I muted? No, you are not muted, Prioritize. You got to really screw up to get muted on my channel. I mean, you got to really screw up, period, to get muted on any of the platforms I'm in, but I don't mute people, although it has happened if you're spamming or being like flagrantly obnoxious, like really, like more than just can't God, you're an idiot. I can deal with that. I get that all the time. I got that last night. I had people call me a stoner and a drunk last night, or an alcoholic, which is, I mean, if you're going to call me one or the other, please call me a drunk. Alcoholics go to meetings. I don't do the meetings. It's a joke. I'm totally kidding. They got triggered because I drink a glass of wine while I'm on sit rep. It's like my thing. It's my thing. Relax, right? 9 p.m. show for me. So I like to chill out. All right. So let's get into this. United States District Court, Northern District of Georgia, Atlanta Division, a brief of independent complainants in support of motion for leave to file brief of amicus curiae. Pursuant to federal rules of civil procedure, prospective amici, I'm going to go with amici. I like amici. Rochelle Cabarak, Kevin Moncla, Joseph Rossi, and Melissa White, the movants, are private citizens and researchers who have conducted extensive good faith investigations and analysis of Fulton County's 2020 election records. Movants filed several serious, meticulously documented, and official complaints with the Georgia State Election Board, and whose findings are directly at issue in the search warrant affidavit and petitioner's amended motion for return of property. So they're saying here that they took this through the proper channels, through the Georgia State Election Board. So this isn't just, somebody putting out a report on X and trying to get clicks. They put this in front of the people that matter, and they have been investigated inadequately. They have not been able to make counterclaims in most of these, and they're putting this forward in the affidavit. Timeliness, we'll go ahead and skip over that. Interest relating to the subject of the action, movements detailed research, data compilations, and complaints to the Georgia State Election Board informed portions of the probable cause affidavit. Very much so, especially the two they mentioned here, which we've gone over ad nauseum on why we vote. In fact, I think it's probably the most talked about topic besides election fraud in general. By virtue of the investigations and analysis of the 2020 election in Fulton County, movements can be helpful to the court's analysis of the pending Rule 41G motion. So the Rule 41G is federal law stating that, you know, if stuff was illegally obtained, unlawful search and seizure, then they have to give it back. That's basically what that means. Petitioners have now placed the assertion of those complaints at the center of this litigation by A, labeling them debunked. We've heard that before. Mischaracterizing their methodology and conclusions and impugning movements' credibility with extraneous and incomplete references, proffering false statements of fact and law. These statements, if left unchallenged, will permanently distort the public and judicial record concerning the integrity of the complaints and investigation of the 2020 election materials. So again, like I said in the beginning, I do have a little bit of insider baseball into some of these things. And so I can say that part of that complaint is the fact that they ultimately were not permitted. It's not that they were not permitted, that the DOJ did not make an argument against the claims against the evidence. The DOJ's claims in the county's motion to dismiss and get their stuff back dealt strictly with legal grounds, right? The Fourth Amendment argument that I talked about earlier. This amicus is going to argue that the evidence is legitimate, okay? And it's going to push back against the county, Norm Eisen's arguments that the evidence is illegitimate. Impairment: if the court's decision is based on an incomplete and materially false record, the court's truth-seeking function will be substantially assisted by consideration of the facts and authorities included in the attached brief, which demonstrate that much of what the petitioners have represented to the court is simply not true. In other words, Your Honor, they're lying to you about the debunked evidence. Debunked. I made that word up. Debunked. The importance of the truth to the cause of justice needs no elaboration. Number 4, inadequate representation by existing parties. The existing parties have not and cannot adequately represent movements' interests. Petitioners are adverse to the warrant and actively seek to discredit the very basis for it by directly attacking certain of the movements. I should have proofread this form. Respondent, the United States in this case, supports the seizure but is not obligated to defend the specific accuracy of the movement's independent research or to correct misstatements about it. So in other words, we have to go do this ourselves. The special agent of the FBI, Hugh Evans, who submitted the probable cause affidavit, is presumably restricted from discussing details of ongoing investigations. And that's the TUI request, right? The TUI request was filed, which a TUI request is basically you have to ask the DOJ if you can subpoena one of their employees, in this case, Agent Ray Evans. Supplementing the record is warranted. Okay, we got all that. So now let's get into the meat and potatoes. This is the third lawsuit filed by or on behalf of Fulton County, BRE, Board of Registration and Elections, concerning 2023-025. Each such action has been initiated without the only lawful prerequisite for a board lawsuit, a vote of board members at a properly noticed meeting. This is huge, okay? So Fulton County has now sued to stop the lawsuits against that complaint, 2023-025. And all three of the previous lawsuits did not go about the legal process required to bring a lawsuit as the board. These are individuals on the board acting unilaterally and saying that we represent the board. No, you don't represent the board. The board represents the board, and you have to take a vote on this at a public meeting, meaning you have to give the 24 hours notice before conducting that meeting. Like all citizens, we have a right to seek a redress of our grievances. We also have an interest in preventing the court from being misled by untruthful information. In this instance, we are forced to correct material mischaracterizations and false assertions offered in support of 41G motion by petitioners and their subject matter expert, Ryan Macias, who participated in and is witness to many of the very actions under investigation. So this is a key part right here. All right. Petitioners and their subject matter expert, Ryan Macias, they're saying he is a part of this case. He can't be offered as an expert. He's potentially a co-defendant if there are criminal charges that are levied from this. In addition, a group of amici, calling itself former Justice Department officials, hereinafter, have filed an amicus brief that adopts the misrepresentation of the petitioners. The material statements of fact and law presented to this court have not been accurate and must be corrected. The present action challenges the PC affidavit authored by FBI Special Agent Hugh Evans and the investigative work underlying the Amicis State Election Board complaints. The Amici, I'm going to do that every single time. I'm just going to go with Amici because that's how I know it, and I'm going to go with it. The Amici have encountered repeated obstacles in the prosecution of their complaints, including material misrepresentations by investigators and counsel for the Secretary of State. Those misrepresentations now form the primary basis for petitioners' challenge to the PC affidavit, the integrity of Special Agent Evans, and the work of the Amici. The undersigned have produced a comprehensive report of the investigation of Fulton County's 2020 elections, which was provided to the FBI. We stand for our work, and the report can be found at the links in the footnotes below. The Amici file this brief both to vindicate their work and to ensure the court is not misled by inaccurate statements of law. All right, we tracking so far? I do have to take a couple breaks here and there just to drink some water and gather my wits. All right. Smash that thumbs up, guys, if you have not done so. Got a little over 500 people watching and 100 thumbs up already, 112. That is excellent. Thank you guys all so much. Appreciate that. And smash that thumb. Let's keep going. Petitioners contend that the PC affidavit contains probable cause. So when you see PC, that means probable cause. The probable cause affidavit means contains material omissions of exculpatory information, and that the Secretary of State investigation reports and testimonies of the Secretary of State's general counsel on which they rely contradict the probable cause affidavit. Okay. So he's saying the Secretary of State, the investigation reports and testimonies from the Secretary of State's general counsel on which they rely contradict their own affidavit. Not their own affidavit, the affidavit that was submitted. Petitioner's position rests on reports that are not dispositive. The Georgia legislature has vested the state election board, not the Secretary of State, with primary authority to investigate election frauds and irregularities. And in fact, they had a fracture from the state election board. The Secretary of State used to be on that board. I think he used to chair that board. They did away with that because this is a conflict, right? The Secretary of State runs the elections. They also can't be tasked with the entity that's tasked with investigating them. The state election board voted to continue its investigation in 2023-025, and on July 30th, 2025, passed a resolution seeking assistance of the DOJ. Again, this is going back to Fulton County filing those lawsuits. The DOJ has attempted to intervene on this. Marjorie Taylor Greene, when she was a representative for Georgia, requested the DOJ intervene. Harmeet Dillon has sent numerous requests to intervene, and the state election board has called on the DOJ to intervene. Fulton County and Georgia are the ones pushing back against that. The investigation remains open. The report cited by petitioners are preliminary and upon examination are not credible. Below, the Amici respond to each specific challenge raised by petitioners. All right, here we go. We're going to get into the meat and potatoes of what is actually being argued in their report. Okay. Let's go ahead and jump into it. Fulton County failed to preserve 375,000 ballot images for all of in-person voting for the 2020 general election, and 17,852 ballot images from the recount were also destroyed. The petitioners contend that Georgia law did not require, Georgia law did not require the preservation of ballot images for the 2020 general election, and further alleges that the affiant failed to disclose this purported fact. All right. Factual response: petitioner's claim is verifiably false and offers no citation at all to any supporting authority. They just claimed it. They just said, you know what? 52-2071 does not require us to save ballot images. Do you have any citations for that? Court precedent, case precedent, anything? Nope. Just take our word for it. Trust us. The challenge relies upon the Secretary of State's investigator's report and the false claim of the Secretary's general counsel as described in the Macias Declaration. The former officials echo the same claim and solely rely upon the declarations of a non-lawyer, but not governing statutes and regulations, to allege that a special agent of the FBI committed wrongdoing. So take Macias, who, as we said, could be, he's got an interest in this case, right? He's privy to it. He's involved in it. Is he a co-defendant? We don't know. He could be. I think that he very well could be. But you can't use his declaration. He's not a lawyer, and he doesn't know what he's talking about when it comes to the law. State Election Board Rule 183-1-12-.13 was adopted January 23rd, 2020, effective February 12th, 2020, which expressly required the preservation of ballot images for the 2020 election cycle. It's in your own law, is in other words what they're saying. State Election Board Vice Chair Dr. Jan Johnston read and applied this rule on the record meeting during the May 7th State Election Board meeting. The transcript, that's part of the evidence down there. The petitioner's expert, Ryan Macias, cites the transcript of the State Election Board meeting for the statements of Ms. McGowan and the state Secretary of State investigator, but omits any mention of Dr. Johnston's reading of the regulation in rebuttal at the same hearing. So they're accusing the petitioner, which is the petitioner's Fulton County. The petitioner is accusing the government, or is accusing essentially the State Election Board, of misrepresenting the evidence that was presented in the probable cause affidavit while they misrepresent what was said during the State Election Board meeting. They only present what Charlene McGowan and Ryan Macias said. They neglect to mention what the vice chair of the State Election Board said when she read the law or the rule that required the preservation of those ballots, those ballot images. Moreover, on April 2nd, Charlene McGowan filed an amicus brief in Favorito verse 1, expressly acknowledging the statutory preservation requirement. All right, this is an important one. In fact, this one's worthy of a pink highlight. All right, let's go ahead and highlight that. I've read a little bit of this already. In that amicus, she said, quote, ballots are then scanned through optical voting scanners. Once scanned, an electronic ballot image is created and stored on a memory card, ballot images. Following the election, county officials must deliver all ballots and ballot images, quote, in sealed containers to the clerk of the Superior Court, end quote, and those ballots and ballot images are to be held by the clerk under seal for a period of 24 months, OCGA 21-2-500A. It doesn't get any clearer than that, folks. Right? So Ryan Macias says they don't need to save those ballot images. And they turn around and they say, hey, the Secretary of State's own general counsel testified in an amicus brief that yes, they do. Yes, they do. But let's listen to the guy who has a conflict of interest. McGowan goes on, the Secretary respectfully requests that the court permit petitioners to inspect ballot images only and deny petitioners' requests to inspect and scan ballots. All right, we can highlight that in yellow. The same briefing, Smith versus DeKalb County, which affirms the obligation to preserve ballot images when using optical scan equipment, has been in effect for some 20 years. 20 years. Thus, at the State Election Board meeting on May 7, 2024, in which she testified that ballot images were not required to be preserved, Ms. McGowan was on the record in Favorito 1 saying they were. You kind of contradicted yourself right there, Charlene McGowan. As she argued in that 2021 brief, Georgia law required the preservation of ballot images, and both were in effect for the 2020 general election. Her assertion on the contrary, May 7th, to the State Election Board was simply and knowingly not true. According to the allegation that FBI Special Agent Evans failed to inform the magistrate judge that ballot images were not required, this is where it gets into what they claimed. The allegations that the FBI Special Agent Evans failed to inform the magistrate judge, can I speak English? Magistrate judge, that ballot images were not required to be preserved for 2020 must be rejected because it is verifiably false. Okay? They made a misrepresentation to the court in that petition by saying that there's no law to retain these when there is a law. There's Georgia law, there's federal law. The Secretary of State's general counsel acknowledged this in a previous case. All right, number 2. Let's pause right there for just a second. Let's just pause 1 second, get a sip of water. There we go. Actually, you know what? Let's hit a sponsor real quick. We do have some sponsors, and let's go ahead and do that real quick. All right, guys, they can cancel your accounts. They can freeze your cards. They can decide what you're allowed to buy, say, or support. Big banks and financial institutions have total control, and they use it. That's why financial independence matters more now than ever. Introducing Rumble Wallet, a wallet built for real freedom. With Rumble Wallet, you control your money, not a bank, not a government, not a tech company. You can buy digital assets like Tether, Tether Gold, and Bitcoin in one secure place. No permission, no middlemen, no cancel button. And when you want to support the creators that you actually believe in, you can use the Rumble Wallet app to directly tip content creators securely, instantly, and without interference. This isn't a credit card line that they can shut off. It's your wallet permanently, yours to protect your future, protect your family. When the system fails, when institutions turn on their own people, financial sovereignty is the difference between security and vulnerability. Rumble Wallet isn't about politics. It's about freedom, ownership, and protecting what's yours. So take control today. Download Rumble Wallet now and step away from the big banks for good. True ownership, true protection, true financial freedom. All right. Let's get back into it here. Petitioners contend, so destruction of 2020 election records continued. Petitioners contend that ballot images are not records to an acting requisite of voting. It's funny that this is one of the arguments they made, because me and Ash talked about this on Why We Vote months ago. There was a lawsuit, and I think it was Mark Elias, or at least his law firm, the Elias Law Group, submitted an amicus in that case and made this argument right here. And I said, this is going to be the argument they use going forward, that 52-2071 does not have anything to do with the actual casting of the vote. It has everything to do with the poll books and voter registrations, etc. Petitioners contend that ballot images are not records relating to an act requisite to voting under 52 U.S.C. 2071, and therefore are not protected federal election records. Similarly, the former officials advance identical arguments, citing the Macias Declaration. The Macias Declaration challenges the probable cause affidavit by stating that the affidavit ignores the important testimony of Charlene McGowan, general counsel to the Secretary of State, during the hearing. Dominion's, this is the factual response, Dominion's manual explains that the system images the paper ballot, and then software analyzes the ballot image to determine the voter's selection. So they're using the actual manual from Dominion in the process here. Analyzes the ballot image to determine the voter's selection. And that's important, because that is a requisite to voting then. And the corresponding page from Dominion's manual attached here too. And it says, quote, this is from the Dominion manual. When a hand-marked ballot is scanned by an ImageCast tabulator, whether at the precinct or centrally, a complete duplex image is created and subsequently analyzed for tabulation by evaluating the pixel count of the voter's mark. The documentation establishes that first, an image is created, which is subsequently analyzed by the software to determine the voter's selection through pixel count evaluation of the voter's marks. Only the digital image contains pixels. The paper ballot itself does not. Without ballot images, Georgia's voting system cannot record, cast, or tabulate votes. Accordingly, ballot images are indeed records relating to an act requisite to voting within the meaning of federal law. The PC affidavit, the probable cause affidavit, correctly identified the destruction of ballot images as a violation of 2071. All right. And did not fail to include statements from the Secretary of State's general counsel because they were false and therefore not exculpatory. Number 3, thousands of ballots were intentionally double scanned and double counted. For the recount, 3,930 ballots were intentionally double scanned and were in fact double counted and included in the official certified results. This is another issue that we have talked about nonstop on Why We Vote. All shows are Why We Vote now. And so, again, this is the Joe Rossi part of the complaint here. I think that's 181, 2023, 2021-181. They've known about that for 5 years now. The 2021 is indicative of when the complaint was filed at the state election board. Petitioner's argument. Petitioners assert that if any double scanning occurred, it was unintentional and that the probable cause affidavit omitted exculpatory testimony suggesting the duplicate scans were not counted in the final totals. Again, I got a feeling that's going to be a misrepresentation. It was unintentional because that's what they always say, right? Human error, technical glitch, human error. Factual response. The cast vote record for the recount contains and include the recorded votes for 3,930 duplicate images, yielding 7,860 votes counted for president. The CVR totals precisely match the official certified totals. All right. That's so important. Precisely match. In other words, the double counts, without the double counts, it wouldn't precisely match. So you need the double counts. So that means the double counts were probably intentional. Confirming the inclusion of votes from the duplicate ballot images. The undersigned provided the state election board with side-by-side comparisons of each original and duplicate ballot image file together with the corresponding CVR entries. This finding is corroborated by declarations from 2 independent experts filed in Curling v. Raffensperger based on data produced under court order. Professor Duncan Buell confirmed that the identical ballot images were actually counted in the tabulation multiple times. And then Berkeley professor Philip Stark also verified that the duplicate images were included in the CVR. Let me see. Hold on. Let me undo that because I'm trying to highlight this for myself as well. The undersigned submitted evidence establishing that the double counting ballots were deliberate and intentional. For each instance constitute a separate felony. So that's 3,930 felonies. You can't, it's for each double scan. That's a separate felony. Each instance constitutes a separate felony under both state and federal law. Furthermore, no statutory provision of the criminal code requires fraud to be outcome determinative. That was one of the arguments they made, that even if they did double count the 3,930 ballots, it wouldn't have changed the results. It doesn't matter if it would have changed the results. Fraud is fraud. It doesn't matter. Furthermore, no statutory provision of the criminal code requires fraud to be outcome determinative. The record verifiably and irrefutably supports the probable cause affidavit's recitation of 3,930 instances of double counting. All right. That is a key point right there. We'll make that one green. Fulton County did, in fact, finish the recount on December 2nd before having to reconcile. This is another issue we've talked about with State Election Board 2023-025 many, many times. 2023-025 included the allegation that Fulton County's results for the recount were initially 17,243 ballots short of the November 3rd results. On December 3rd at 12:13 p.m., Richard Barron sent an email to Ryan Macias with an attached report showing the recount results of 543,000 ballots cast. Somehow, over the 24 hours that followed, nearly all of the shortfall was found. Now, the petitioners, almost spilled my water. That would have been bad. The petitioners state that the affidavit puts forth a flagrantly misleading narrative of the timing of the recount in Fulton County, falsely implying that the county manipulated its ballot count by uploading votes that arrived out of thin air. Petitioners claim that the county was not done and that the number was the running total as of the deadline. There's a tweet that's going to refute this. Quote, a date on which it was understood that thousands of ballots had not yet been counted. So in other words, the petitioners argue that the 511,000 wasn't finished. We still had more ballots to count. We just gave that number with the assumption and the understanding that we're done counting. on December 2nd. Okay, let's keep reading. They say that the, quote, the affiant inexplicably omitted an exonerating section of the Secretary of State's report. Factual response. The omitted Secretary of State's investigators' report and statements from the Secretary of State General Counsel are not, quote unquote, exculpatory because they're not true. At 11:52 on December 2nd, Fulton County publicly posted on social media that the recount was complete. All right, that's a key right there. So Fulton County, their own admission on X, formerly Twitter, I think it was Twitter back then, was the recount was complete. But wait, they said it's not done. It's a work in progress. No. They told us on X, Fulton County's official X account, it's complete. The following day, Election Director Richard Barron emailed Ryan Macias a report showing the 511,000 ballots cast, 17,000 short of the November 3rd total. Interestingly, Mr. Macias referenced the Secretary of State's investigation report instead of the batches loaded report sent to him by Rich Barron. Richard Barron was the director of registration and elections. The petitioners, nor their amici, nor Mr. Macias himself disclosed that he was the recipient of the email from Richard Barron and that with the recount of 511,000 ballots total. So he's saying that Macias is pretending like he doesn't know what's going on, but he was the actual person that received that email. It was not Special Agent Evans or the amici that made the claim that Fulton County had completed its recount. It was Fulton County itself. But there is more than just an email and a tweet. Dun, dun, dun. There's a December 4th, 2020 meeting of the Fulton County BRE at which Barron states the recount was finished. Again, there it is. And I've actually played that clip. It's on YouTube. I've actually played that clip on Why We Vote and this show, I think. And here's what he said, quote, "Now, with regard to the recount, we concluded that on Wednesday night, we submitted our results, and then yesterday, the state allowed us to do a reconciliation. So it wasn't a continuation of counting, it was a reconciliation. There's a big difference between you're carrying on counting and, hey, you fucked up, you better reconcile this. Big, big difference. Big difference. December 2nd was a Wednesday. The board certified the recount results on Friday, December 4th, not the 7th, as Macias states. According to Director Barron, the county uploaded results it believed were final on the night of December 2nd, or officially very early on December 3rd. Only afterwards was Fulton County directed to reconcile. The sequence of events is corroborated by Fulton County's own contemporaneous public statements and board meeting testimony. Therefore, the probable cause affidavit accurately describes these facts. The record, including the verifiable and publicly available statements of Fulton County's elections director, robustly supports the assertions made in the probable cause affidavit by Special Agent Evans. In other words, again, for a third time now, the petitioners in the probable cause motion are not being honest with the court. They're not being honest with the court. And it's not like some, crazy error that they made. They're completely misrepresenting testimony, completely misrepresenting evidence, and completely misrepresenting law. The petitioners, and especially their expert, Mr. Macias, omitted material facts, belying their claims and corroborating those of Special Agent Evans. All of these underlying facts were laid out in 2023-025. Number 5, tabulator tapes are statutorily defined and required by law. 138 precinct tabulator closing tapes for early in-person voting representing over 315,000 ballots are unsigned, unwitnessed, and uncertified. The quote-unquote official returns were produced on surrogate tabulators and bear the serial number and protective counter number of unknown machines. Unknown machines. How do you have unknown machines in an election for the president of the free world? Additionally, the security seals were cut and memory cards for 35 tabulators were unlawfully swapped during a live election. That is damning. And not due to memory card capacity. Petitioners argue that the affidavit misleadingly omits the Secretary of State's conclusion that tabulator tapes have no relevance to official vote counts. This is an argument that they're actually making, that the tabulator tapes have no relevance to the official vote counts. That is crazy, especially considering one of those tabulator tapes is the one that proves that there were no ballots preloaded on the machine. You don't need to see that. Why would you need to make sure that the machine started zero? Why would you need a tape showing that when you were done, the tabulator showed X number of ballots? You don't need that. You have the ballots. And oh, by the way, you can never, ever look at the ballots. And that, quote, they are merely additional documentation of the ballots cast on the precinct scanner, end quote. And that, quote, the improper signatures on some Fulton County tabulator tapes were an administrative oversight. Factual response. The Secretary's assertions that tabulator tapes, quote, have no relevance to official vote counts and are, quote unquote, merely additional documentation are as reckless as they are false. I love that. As reckless as they are false. Georgia law defines tabulator closing tapes as the official returns and explicitly requires the returns to be certified. Georgia law. Georgia law. Georgia regulation also mandates, quote, for each ballot scanner, 3 tapes are to be printed showing the vote totals as cast on that ballot scanner, and that 3 witnesses shall sign each of the tapes. Now that's rules and regulations, but it's still what's, put forward. That's what they have to follow. It just doesn't carry the penalty of law as civil. Thousands of fictitious ballots and votes were intentionally added to the hand count risk limiting audit. At the end of the results of Fulton County's hand count audit in 2020, Georgia resident Joe Rossi documented problems with the audit and submitted them to the governor. The governor replicated the findings over several weeks, and on November 17th, 2021, referred the matter to the state election board. It became 2021-181. Petitioners argue that the Macias Declaration includes claims that the hand count audit, quote, has no bearing on the outcome or determination of the election. So in other words, we did the hand count for nothing. If it matched, we're going to throw it in your face that it matched. But if it doesn't match, it doesn't mean anything. Are we seeing the hypocrisy in those statements? Because they tell us all the time they did 3 counts in Georgia. Okay, none of the 3 counts are even close to matching, and the hand count has huge discrepancies. Oh, but that's not an official count. It doesn't matter. Then don't tell me that they did 3 counts and use that as some sort of a data point that, a proof that the election was clean. Don't tell me that. Okay, stop with they did 3 counts if you're going to argue when the 3 counts don't match up. Factual response. As a result of the 36 documented errors in the hand count, 6,691, almost 7,000 fictitious ballots that do not exist were added to the total ballots cast column. This was not the product of data entry error. Batch tally sheets were intentionally falsified. After correcting for the false numbers, Fulton County's total ballots cast for the hand count was 521,000, which is 7,436 less than the certified result on November 3rd. From a review of only the absentee ballots of one county. So that 6,691 duplicates was only out of the absentee ballots, which I think there were like 148,000. So that means there's like I think it's either 4 or 6% error rate in the counting of the absentee ballots. 4 or 6% error rate. Now keep in mind, Trump, quote unquote, lost Georgia by 0.25%. And you're looking at a 4 to 6% error rate in the hand count. Fulton County knew about the errors because on November 19th, 2020, a member of the elections group sent the same list of errors to the election director. The individual tasked with reconciling the hand count was Ryan Macias, formerly with the elections group. Do you see why I'm saying he might be a co-defendant in this, and therefore the court cannot rely on his expert testimony to try and throw off this case? He very well might be. Like, how does the court not look at this and say, hey, take this Macias guy's affidavit with a grain of salt? He could be complicit in this. He was intimately involved in the election process. The 36 errors were corroborated but never corrected. So Fulton County entered a consent agreement over this. Number 7, fraudulent ballots. Following the hand count, witness gave sworn affidavits stating there were batches of absentee ballots that were filled out by machine, appeared to be pristine, and were never folded. We've heard that one. That's Susan Voiles testified to that. So did several others. I think Bridget Thorne might have. I'm not sure. But several others have testified to those same claims. Petitioners claim that there have been many investigations into Fulton County's general election. They argue the matter of pristine ballots has been investigated and that the affiant omitted that fact, and that he omitted the material information that tabulating military and overseas votes regularly results in pristine ballots. They say that included in the affidavit is the testimony of witness 6, whose claims preclude even the possibility that fraudulent ballots were injected. Factual response. First, the suspect batches identified during the hand count. Let me read that again. First, the suspect batches identified during the hand count, however, batch composition and integrity were not maintained. That's a very poorly written sentence. First, the suspect batches identified during the hand count, however, batch composition and integrity were not maintained and were materially altered during the recount. There's no correlation of ballots and batches from the original count to the recounts. Okay, so in other words, and that's not very well written. That's a grammar error. In other words, they're saying when they went and looked for the batches that was pointed out during testimony to find these pristine ballots, they didn't find them. But what they're saying is after the recount, everything was shuffled up. So you went to go look for them, and it wasn't the same batch that it was before. So if you go look at, like, let's say batch 12, ballot number 8, before the count, it's not the same batch 12, ballot number 8 after the recount because they shuffled it all up. The effective shuffling of 2 machine recounts, one failed, before the matter was investigated, rendered the prospect of identifying and consulting the same batches identified during the hand count impossible, as they no longer existed. This is a key claim right here. And if they can prove this is why they're investigating. This is a big deal. This is a big deal because now you've got 2 issues here. First, there's pristine ballots being injected into the count. Second, were the counts deliberately shuffled? Were the batches deliberately shuffled in order to obfuscate any investigation? And when you go back to the Rossi report and what Joe Rossi found with the 6,691 duplicates, that's what they did. They shuffled those up, put them together in batches, and then double scanned them so that you wouldn't recognize them from previous batches scanned. They also did the same thing, it seems, in order to block anybody from being able to see the pristine ballots. Because when you go back and they say, hey, we need to go back and look at ballot number 5 in batch number 12, ballot number 5 and batch number 12 is not the same as it was on November 3rd after the December 3rd machine recount. They're changed now. But they checked that off and said, we looked at it. The ballot was fine. Bullshit. Is that making sense, guys? Are you guys making sense? Is that making sense? Give me a thumbs up in the chat if that's making sense. Also, if you're a unique chatter, if you're listening and you don't normally jump in the chat, jump in and say hello. I might run here in just a second and refill my water. I apologize, guys. I don't have my big glasses. I only have this little beer glass, pint glass. Somebody called me an alcoholic, so it's only fitting that I'm drinking out of a pint glass. It is water. There we go. By the way, definitely not. All right, 5x5. Everybody's tracking. There we go. Let's go. You guys are all smart because you've been watching Why We Vote for the last 3 years, and you guys know all this stuff. This is like a refresher course for you. But I want it on record because maybe you'll share this out with some people that think the Fulton County thing is a joke and that, they're lying. The FBI is lying to do this. They're not. In fact, Norm Eisen and his group are misrepresenting to the court actual facts. All right, let's keep reading. Second, the assertion that the Uokava ballot duplication process would yield pristine hand-marked paper ballots is also not true. Ballot marking devices were used to duplicate Uokava ballots. In other words, they have QR codes now, right? They have QR codes instead of, we'll do that light blue. They have QR codes instead of being hand-marked paper ballots. Third, Fulton County did have extra ballots sitting around. In fact, they had 1.058 million extra ballots ordered by Fulton County. I broke this story. I mean, granted, it's their work, but I broke this story to the public in 2021. I think it was 2021. The Runback, the company in Orlando. Yeah. Nobody wanted to listen to me back then. And now all of this stuff, I love this, man. I fucking love this. Sorry for the swear word, but I love this because this is vindication. I don't think you guys understand. This is stuff that, I mean, these people, Kevin, Rochelle, Melissa, Joe Rossi, they've been working on this relentlessly for 5 years. And being, friends with most of them, and social with all of them, I've been covering this for 5 years and trying to get as many eyes as I possibly could on this. And here we go. It's starting to come out, and I love it. I am so excited. This warms my heart to read Norman Eisen having to melt down and make up misrepresentations to the court in order to try and stop this from happening. It's almost like nothing can stop what is coming. There was no reconciliation performed for the 2020 election cycle. Lastly, perhaps the reason that there have been no credible investigations into Georgia's 2020 election is better understood by the sworn special purpose grand jury testimony of United States Senator David Perdue. Ooh, where did this story come from, anybody? Senator Perdue describes requesting the director of GBI, Vic Reynolds, to investigate evidenced violations of Georgia law with regard to the 2020 election. Weeks later, Director Reynolds said he would not investigate because the governor did not want him to, and that, quote, he was a team player. See the corresponding transcript. This was the story that I broke. I broke this story. Again, I got sources. I'm pretty sure you could figure out who my sources are on this story. Well, I mean, it's not, they're the ones that gave me the transcript. I was reading through it. But this was a big story. So David Perdue, senator, in the grand jury testimony with Nathan Wade asking questions, said that the director of GBI, Georgia Bureau of Investigations, came to him and he said, hey, Vic Reynolds, I got problems. I got problems with how the election was run. I think you need to look at this. And Reynolds said, wow, this is really compelling, but Brian Kemp does not want me to investigate it, so I'm not going to investigate it. And David Perdue was like, son of a bitch, why are you not going to investigate it? I'm just not going to investigate it. My hands are tied. I'm a team player. And so he didn't investigate it. And then he went on to become a Superior Court judge in Georgia, appointed by Brian Kemp. Let that soak in for just a minute. Good? Okay, let's move on. His Honor, appointed to the Cobb Superior Court bench in 2022, is not the only player on that team. He's not the only player on that team. There's more is coming. We'll just say that. The petitioners in the conclusion, so we're almost done. Thank you guys for sticking it out. The petitioner and the Secretary of State's general counsel would have you believe that the destruction of ballot images doesn't matter. The official returns, the tabulator tapes, have no relevance. Intentional double counting of thousands of ballots wasn't outcome determinative. Fabricated tally sheets adding thousands of bogus votes to the totals is acceptable, and the rule of law is but a suggestion. They claim that the paper ballots are the only record that matters, but those can't be accessed because every other election record used to show probable cause does not matter. Signed, those individuals. And I'll leave that at that. Now, if you guys want to go through all the exhibits, I'm not going to go through them. There's like 30 pages of exhibits. But all of this, every claim that's made in there is backed up. Okay. I would not, when I do these things, I bring the receipts, so to speak, right? And there are plenty of receipts on all of this. So, again, tune in to Why We Vote tonight, 7:30 p.m. Eastern. I'm going to try and get somebody on that can do a kind of summary of how the hearing went today. hopefully Norm Eisen, Abe Lowell, and the Sue Joe, hopefully those attorneys get a little bit of a reprimand from the federal judge over misrepresenting to the court on numerous occasions. Hopefully we can get rid of this whole bullshit. It's been debunked. Conspiracy theory. It's not debunked. It's not a conspiracy theory. This is all real stuff based on very, very good evidence that's right there for you to see. Like anybody that says there's no widespread evidence of fraud, here is the evidence. This is the evidence. And by the way, this is the evidence that leads to the investigation into whether or not these things were actually in the commission of election fraud. I believe they were. I think everybody listening here believes they were, but we still have to conduct the investigation. And they are spending millions of dollars and have been for 5 years now to prevent anybody from doing that investigation. I wonder why. I wonder why. All right, so let's see what else we got. Let's pause for 1 second here, and let's talk about another sponsor of the show. You guys know that I absolutely love silver, but both silver and gold financial, are significant financial hedges, right? Your 401, your IRA, you want to make sure that you are diversifying. You don't want to have everything in just cash, because what happens with cash? You bleed off a little bit every year. It's called inflation. And we saw a lot of inflation. So I've been telling you guys for a long, long time how much I love silver. Gold is right up there with it. I'm just more of a silver guy. That's all. It's just personal preference, really. But either silver or gold, excellent ways to hedge your bets and safeguard against any crises that may be happening. Check out Augusta Precious Metals, my sponsor here. You can go to, let's see, the website is in the link down below. Yeah, the website is in the link down below. Or very simple, you can simply text CanCon to 35052 for more information. Again, CanCon to 35052. And again, I'm going to leave that up there for a second. I freaking love the precious metals. Love the precious metals. And let's see. Yeah, we can also talk about our friends over at 1775 Coffee. Have you tried it yet? Now is your shot. The 1775 starter kit just dropped with only 1,000 units available. You're getting the bold dark roast that hits hard, the smooth medium roast, and the vitality mushroom coffee for clean energy, laser focus, no crash. All single origin, small batch, toxin free, and mold free. Plus, you're also getting a gold spoon clip because freedom isn't scooped with plastic, a frother strong enough to stir up your coffee and your mother-in-law's opinions, and a black 1775 tumbler, $170 worth of coffee and gear for just $99. This is for the ones who've been watching 1775 blow up on Rumble, wondering if it's actually worth it. Spoiler, it is. Go to 1775coffee.com/studio and grab your starter kit before they're gone. Bold beans, clean fuel, and a morning routine that stands for something just like Rumble does. All right. And I think I forgot to mention, with Augusta Gold, you can text that number 35052 to get a free information guide and just learn. That's all you're doing is learning about, diversifying your 401k, IRAs, retirements, whatever the case might be. And that is awesome. So smash that thumbs up if you have not done so already. We did get a rant. Oh, no, we got a gifted subs from AJC the third. AJC3 gifted 10 subs. Thank you so much. And I'm hoping and I'm praying, and I know that this is probably the case, but I'm hoping that AJC does not stand for Atlanta Journal-Constitution, because that is a leftist rag that writes a lot about all this stuff, but never gets it right. Well, they probably do sometimes. They're just very partisan in how they present their stuff. Okay, so I think that is going to do it. Again, tune into Why We Vote tonight on Badlands Media. And let me see. I got to find somebody to raid you guys over to, because I have to do a certain number of raids. And so let's go ahead and find somebody to raid you over to. Any suggestions on a good podcast to raid you guys to? I'll keep this chat open. If you guys are in the chat, I'll keep this chat open, and you guys can go ahead and listen to that. Hmm. Oh, you know who I like? This guy's kind of cool sometimes. We'll raid you over to Devori Jet Darkins. Viva's at 3. Oh, you know, I can hang out. I can hang out till 3 to raid you guys over to Viva. What do you guys got for questions in the chat? Let's do that. I will stick around until Viva is live. I like David. He lives like 30 minutes north of me, and we keep talking about like getting together, doing dinner or something, and we never do it. I gotta make that happen. Got to reach out to him and make that happen. So let's see. Is he live at 3? Because I don't see anything. Oh yeah, there it is. Starting at 3 p.m. All right, so we will raid you guys over to there. I did say any questions in the chat, so I will check real quick. Too funny. Badlands is on with Ghost. Oh, are they? I didn't even check that. Oh shit! I got to raid you over to Badlands then. Got to raid you over to Badlands. Got to raid Ghost, man. Ghost is my homie. Ghost is. Oh yeah, he is live. All right, we're gonna raid you over there. All right, we're gonna raid you over there. What wine do I prefer? Okay, so you talking brand or type? I am a Pinot Noir and a Cabernet Sauvignon guy. I like cabs and Pinots. Anything red though, I'm usually okay with. Not a big fan of red blends, although they're not bad. But if you're gonna get a red blend, you got to get a good red blend. You can't do like 19 Crimes. You can't 19 Crimes isn't too bad, but you can't do like the some of the cheap wine. And I know sounds kind of cocky, but you know, sometimes the cheap wine, I mean, great, cheap wines are fine, but they're too sweet for me. They're too sugary. So you know, if you're going to get a red blend, it's got to be a decent red blend. I've been drinking Special Reserve is a local. I don't know where the brand's from. I think it's California wine, but our wine, our store carries a lot of it. So I've been drinking a lot of that. I like Juggernaut Cab. I don't like the Pinot so much, but the Juggernaut Cabernet is good. What's another one that's pretty popular? DNA Vineyards is pretty good. Portland Project is pretty good. I don't know. I'm kind of drawing a blank on the rest of them. 7 Young Blondes. I love 7 Young Blondes. Just one, my wife. But yeah, I use cheap wines to cook with $6 or $7 a bottle. Yeah, cooking with a $6 or $7 bottle of wine is great. My bank account is too low. So is mine. Trust me. I argue with my wife. I'm like, are you sure you need another glass? You don't need another glass. Save it for me. And when I mean, the average price of the wine I get is probably like $12, maybe $14. And then like we'll spend like 18 or 20 if it's buy one, get one free. So we go to Publix, buy one, get one free. And there we go. E.H. Kyle. Yes, I have somebody in the courtroom as well. We will have an update as well. So thank you for that. Robert is awesome. Gouvier is awesome. He does a great job covering all this stuff. And he is an actual attorney, so he has a little more insight to some of the stuff broadly. But when it comes to this, nobody has more insight than you're getting here, unless you're talking to the people that drafted the work. You know, there's nobody that knows this case better than me. The election side, the legal side, I would defer to Robert on that. But in terms of the evidence and how all this came about, how long it's been about, what specifically there is, nobody really knows this better than me. And I'm not being cocky. It just is. I've been neck deep in this for 5 years. To the point where, I mean, I talk like these are friends of mine. Like if I was ever going out to, I'm not going to dox them and say what state they live in, but if I was ever out in that state, I would absolutely call them and be like, hey, let's go grab dinner, right? Like, we're friends. The only grapes that grow in Florida are sea grapes. This is true. They're also not real grapes. They're also illegal to destroy. They also don't survive sub-freezing temperatures because all the sea grapes right now from that cold we had this year are dead. Like dead. So I don't even know if the sea grapes are going to come back. Neckbeard, I ain't got. You got a neckbeard? No, I trim it up under there. Gatorbait, you've been on Fulton County for years, the OG of Fulton County election fraud. Well, Garland Favorito would be the OG of Garland election of Fulton election fraud. 2020 election fraud, I'm one of the few. Me, Wendy Strzok Mahoney has been on top of it the whole time. Heather Mullins has been on top of it the whole time. The people that were in that probable cause affidavit or the response to the amicus brief have been on it the whole time. Garland, of course, has been on it. David Cross, I almost said David Cook, Mark Cook, although Mark Cook is much more broad. What else we got? Who else has been on this? There's some people. The AJC has been on it. They're just not honest. They're not honest. And that's it. That's all there is to it. Okay, let's wrap up here. I'm going to send you guys over to Ghost over on Badlands. Let him know that I sent you over. Love that guy to death. Tell him I said what's up. Stay frosty. God bless each and every one of you. God bless America. Make the fortune cookie country pay for this.